Anyway, I'm going to jump right into it. There's a number of slides and there's a number of topical kind of issues when deciding about closing your business that I want to get to. And then I have some specific questions that I've gotten recently from just inquiry. So a little bit about myself and the law firm. I'm Ryan K. Hugh. I'm a business attorney, obviously here in Honolulu. I think most of you are on Oahu. And I generally help small and medium-sized business owners from forming businesses, securing licenses, doing agreements, and then yes, unfortunately, sometimes discussing what their options and plans are to close down their business. Obviously, this inquiry has gone up a little due to the pandemic and the regulations that have ensued from the pandemic. So I thought, why not just kind of offer this up? We are recording the video. We might do some light edits and then decide to throw it up on YouTube. Again, I got to coordinate with my staff, but I think if you're just tuning in and I'm kind of ambient noise, or this is kind of like the radio, or you're working on something else during your lunch break, we will try and get you a link so you can rewatch the video or kind of highlight kind of topical areas or share with other people that might need to know this information. With regard to the information, just quick disclaimer, just like any webinar that you may have attended or legal seminar, whether it be for accountants, attorneys, or any other type of professional, just the disclaimer is that this is general legal information and it's non-specific. Basically, if you feel that you need direct assistance or representation, you should probably schedule some type of consultation with an attorney or professional to kind of discuss what your exact situation is so you can get the advice you need. And in cases of especially dispute lawsuits or things like that, representation might be needed. So with all that being said, let's jump right into today's topic. So this is what the agenda is going to be. Going into intro disclaimer, which I just did. In terms of the webinar topic, I want to zero in and focus on it because it's not about bankruptcy, but I will give a brief word on bankruptcy just so it kind of grounds, because a lot of people, when they think about closing a business, their mind immediately goes to bankruptcy. It's not quite that one leads into the other. One is more part of the process, depending on your situation. After that, I'll go a little bit about why you should consider following the formalities of closing down your business. I've seen a lot of situations where people don't follow it and they've kind of increased their liabilities, personal. Then on the next slide, we're going to kind of talk about how to analyze or map out the business's liabilities. For the sixth topic, I'm going to go over some of the bigger problems that people face when kind of moving and navigating the closing down of the business. Following slide on that is just alternative options, what things to consider. And then the last slide is really about recent questions that I've kind of gotten and I kind of wanted to share with all of you. Again, thank you for joining me on your lunch hour. I hope it's kind of helpful, but I also wanted to share exactly that other people share your concerns or wanted this kind of information. And then as we get to the last slide on recent questions, I think Leilani is going to prompt you all to submit your questions, and we'll pick a couple, or seeing how much time we have, is go through them. So today's webinar topic is really focused about closing down your business and analyzing risk and liabilities and trying to mitigate or at least lessen your personal liabilities with respect to the business. Specifically, it's about the formalities of LLCs and corporations. I will touch briefly upon here and then, if I can, on sole proprietorships, but generally, because people take formal steps to form LLCs and corporations, you also have to unwind and undo that formality. And then you also have to deal on top of ongoing liabilities and obligations related to the business entity, mainly contracts, mainly all the types of contractual matters. There are other issues, so compliance issues like taxes, canceling registrations and licenses. Again, this webinar is not on bankruptcy in of itself. Segueing into that, just so that if you did come here for a little bit of bankruptcy, I do want to give a brief word. So bankruptcy is a federal legal process. There's actually a separate bankruptcy court, and many attorneys practice in that direct area. I myself do not practice in bankruptcy, and I generally work with a bankruptcy attorney on the business entity side, that is on the LLC or the corporation side, in terms of giving advice or conferring with the bankruptcy attorney about what the structure of the entity is or what the relationship of business partners in the entity is. In terms of bankruptcy, the reason why is A, again, there's a federal court for it, and B, there's three types of bankruptcy, and a business owner may or may not qualify, and not to mention their intention isn't, it may not fit nicely into any of the three types. So generally for smaller businesses, usually what they tend to look at is some type of Chapter 7, especially if they're going to close down. And so that's what I was trying to express earlier is that bankruptcy is part of the process of closing your business, but it isn't the end be all. There are things to take care of even after the bankruptcy. So I'm just more focused on the kind of the whole concept of closing down a business entity and dealing with the liability as to that business. This isn't really focused on an individual. And so an individual is a living, breathing person. And we're going to talk a little bit about why it's so important in terms of the formality of recognizing business entities as separate persons, because it helps you analyze the liabilities, is that bankruptcy can sometimes be tied to an individual who is a business owner has maybe over leveraged themselves. But the question is also, is the liabilities attached all to the business? And that's usually when you have a liquidation event, the business goes out of business and then sells everything. And then the bankruptcy trustee, the person appointed to oversee the liquidation, basically takes all those assets and tries to pay off as much debt as possible. So that's bankruptcy in a nutshell. If you have questions or want referrals, or you know somebody who might need, we're happy to give those. There's a number of attorneys, like I said, that we work with or refer to. Okay, that being said, let's kind of open up a question to you attendees, because this is going to help me kind of focus on, as I said, we're focusing on LLCs. But what kind of business entity do you have? It matters to some extent for closing down a business. Okay, great. All of those, so the results that I have is overwhelmingly, so 5 of you have LLCs, which is great because that's what I generally tend to focus on. I do have a number of corporate clients, but for small, medium-ish, I know that's not really helpful, but small to medium, smaller size, medium, or people who are growing their business up to medium tend to use LLCs because of their flexibility and ease. And corporate taxes and the corporate governance structure tends to turn off a lot of small, people don't want to do paperwork. I know dealing with your attorney and accountant is kind of a headache already, but so usually people focus on an LLC. So I'm going to focus on that for my discussion. But overall, in terms of the formalities, you need to understand that an LLC and a corporation both give its members or owners for LLCs and shareholders for corporations limited liability. That's why most people fall into this. I need to form an LLC or corporation because I don't want my personal assets on the hook. And that's kind of right, is that you're limited up to the liability of what you contribute into the business. But notice that when you form the business entity to create that separate entity, you know, the LLC is here and you guys are members or owners here, throughout running and keeping the business going, you wanted to separate your personal assets, your personal identity from the business assets and personal identity, I mean the LLC's identity. So in general, you have to extract yourself or get yourself out of this situation by following certain formalities. The reason being of attorneys' emphasis in keeping the identities separate a lot of times is because if you fail to follow the formalities, it allows creditors, people basically angry at you, of exposing you personally to lawsuits and actions. Basically, the court and public policy is, if you can't follow the basic kind of corporate or LLC formalities of having that separate identity, then why should we give it to you in a lawsuit? And so when closing down your business, you want to kind of generally follow a certain kind of steps. And the meaty part is kind of where we're going to focus on in the later part of the slides. But usually for a business owner, they're starting to feel overwhelmed, profits are down, or the business is outright closed. Definitely feel it for a lot of the food and bar establishment, because that's some of my clients and it's very painful to watch. But the business owner up late at night decides to close. Frequently in LLCs that are multi-member, that is, there's multiple members, they do have an operating agreement, and there is a process or a procedure usually outlined in the operating agreement for the business owners to collectively decide to dissolve. So when you hear dissolution or dissolve, a lot of times in legalese, that signals to the attorney that this entity, that there is an entity and the business owner or owners have collectively committed to breaking apart and basically tearing down the business. So what does that generally look like once you have gone through, I've decided to close, I've looked at the operate, we've taken a vote or we've had a meeting, now what's next? So the meatiest part is kind of at law, under LLC law, we use the term winding up. This is where most of the work to close is done. Winding up basically at law gives people who are in control of the LLC, and by the way, I will touch upon corporations slightly because the process is similar to this. Not to leave people with corporations out on the cold, but I'm just focusing on LLCs. Anyway, back to winding up. At law, winding up gives you a number of responsibilities, which is, for example, preserving the LLC's business or property as an ongoing concern for a reasonable time. So just understand dissolution and dissolving under Hawaii law is a decision to go through this process. But the LLC is not done because you're keeping it going to take care of certain outstanding liabilities and debts. Or oftentimes you keep you have decided to dissolve, but you keep the LLC open because you are prosecuting or defending against lawsuits. You're settling disputes. You are closing bank accounts or winding up business agreements and arrangements. In addition, the LLC still exists as you dispose or transfer the LLC's property, whether it's cash, whether it's furnishing and fixtures, it's inventory. The goal being of disposing and transferring those assets and the property of the LLC is to discharge the LLC's liabilities. Sometimes it's a negotiation. Maybe you're trying to get out of a lease. Other times it's sell all inventory, so we don't need to keep it, and then we're going to shut down. We're going to try and get out of the lease. It's only usually at the tail end that if there's any money left in the business bank account or if there's any assets left in the LLC, then you divvy up the remaining assets amongst the members. A lot of people like to put that at the top And what it actually looks to creditors or other people you owe things to is it looks like you are defunding the LLC so that they have nothing left. Because part of the process of keeping the LLC open and being a member or a manager on the LLC is to negotiate and settle those disputes or those creditor claims while ongoing. Some people like to put basically the cart before the horse and be done and kind of take out all the money and kind of flee. That is exactly what you don't want to do, because to the outside world, that looks like you're kind of just cashing out and running and not taking the responsibility of properly closing down the LLC. So really quickly for corporations, it follows a very similar path. It's just that it uses different terminology. So for instance, if I mention articles of termination, that's usually for an LLC that we file right at the end to say, yes, we've taken care of everything, the LLC no longer exists. Usually for a corporation, we file articles of dissolution or the corresponding phrasing. The only reason that corporations tend to be more complex is there's more rights for shareholders than members and managers, and the process at corporate law tends to be more outlined. And some of the problems with corporations, even small ones, is that there's an investor type of relationship to the founding business owner. That is, they have passive investors. And because of that, a lot of times corporate shareholder meetings tend to be a very slow, long drawn out process to even get to, you know how I have decide to close and procedure to dissolve. 1 and 2 tend to take a long time with corporations, especially if there's multiple shareholders. So let's jump into some of the liabilities. Quick mention, for these next 2 slides, the mapping out liabilities and some of the biggest problems, I actually have 2 blog posts that also cover more in detail. And so we'll probably send up a follow-up email and you guys can take a look at that. There's some helpful checklists and there's things that people consider. But for my part, for today, in terms of liabilities, I usually tell people is you need to analyze if it's usually on the ownership level, that is you've personally done something and it's impacting the business and that those liabilities have bled over, or is it at the entity level? Is the contractual relationship with a creditor, supplier, vendor, or contractors, customers with the LLC or the corporation? And then internally, if you have multiple members or managers or employees, do you owe them something? For instance, the last one in terms of employees, when you're winding up the business and you know you've either terminated or let go your employees, there are certain things on the compliance end that you need to take care of that for obvious example is paying them out. If you don't pay them out, you can't really close out the LLC because you still owe them an outstanding obligation. Like I said, there's lots of horror stories where a business owner is, oh, there's no more money in the, I can't pay payroll, so you're out, fresh out of luck, and they close down the LLC and kind of try and escape liability. The Department of Labor and the Department of Taxation and IRS will go after you because you still owe these people that you've kind of left out on the call. So another way to think about this process, other than analyzing who you have outstanding obligations and liabilities to, which is mostly going to be contractual, but there might be some what we call tort claims, is the bankruptcy process. So understand in bankruptcy, usually when the bankruptcy trustee is kind of organizing how to pay off debts and liabilities, what do you owe in government taxes and fees? You cannot escape those because you owe the government for taxes. A lot of times for first-time LLC members, I discover that many of them haven't been paying certain taxes or they didn't realize. Their understanding of taxes is when you don't have to pay, the LLC doesn't have to pay income taxes. Some people run away with, oh, I don't have to pay any taxes. That's not true. Usually the biggest problem in bankruptcy and this mapping out of liabilities is identifying which creditors are secured and which are unsecured. Because the order is secured creditors, because they understand they've drawn out a contract with you, the business owner, of securing themselves in the bankruptcy process to get at those assets. They have a personal guarantee, which gets at you at the personal level, or they've taken collateral, which means they do not need to be subject to bankruptcy and just seize the collateral. Unsecured creditors are your kind of day-to-day kind of average contract, or didn't take steps to secure what we call securitize the relationship of the contractual situation. And usually by then, the assets of the business in bankruptcy have run out. The last group to get paid are the members. So circling that back up into how I broke it apart, there's two ways to analyze is you need to take care of everybody else first. And usually one of the first thing is analyzing external kind of relationships with creditors, suppliers, and vendors, contractors, and customers, and seeing, is there a way for me to negotiate creating payment plans, or is there a way for me to reduce what I owe and kind of deal with the over outstanding debt obligation? And then in terms of employees and managers, you take care of them. And then finally, it's members in terms of their business relationship, partnership, that if there's any assets, they'll get. I see we're running out of time, so we're gonna go over a little. If you guys don't mind bearing with me, I wanna make sure you guys get some questions, but jumping down to the next slide. So some of the biggest problems when closing down is when you decide to close, especially for your long-term arrangements like leases, loan obligations with financial institutions, let's say in terms of buying on credit with some type of vendor or supplier, there's notice requirements usually in your contract, or there are termination clauses. There are basically hooks and ways for other people to kind of figure out where they stand with your business in terms of their longstanding agreements. In general, for commercial lease situations and certain business loan obligations, usually the bank and landlords try and get a personal guarantee from business owners. So if you're in a restaurant or retail situation, you're going to want to analyze, am I on the hook still personally, even if I wind up the business properly and close down the LLC or corporation? Do these large players, that is commercial landlords and financial institutions, can they still grab at my personal assets? If that's the case, you're going to really want to spend time with them of either creating a payment plan or trying to deal with that situation, or again, negotiating is that, you know, my business is shut down. How do you want to do this? Because again, the running and hiding thing will only just make it that much worse if they have personal guarantees. Other times, other ways that parties secure themselves is seeking collateral. That is, there's some type of property that somebody has a security interest in. And the reason why that's important for closing down the business is, depending on the character, the creditor will try and seize that asset. If it's equipment, like if you're in construction or contracting, yeah, that's sometimes when you see the represent or somebody give notice is that we have a security interest that we've come to collect and take it off. Other times when it's intangible assets, there is some work that has to be done on the creditor to try and get at that collateral. Switching to some of the other things, one of the biggest problems is business partnership disputes. I frequently see this is that if, especially in two-person LLC membership situations, is one member thinks you're going to weather this storm and they want to keep going, and the other business partner wants out and they're done and wants to just close. Because the business is not generating revenue, or they don't have a really good operating agreement, the two members are at an impasse. And so the thing is one wants to keep going and the other one wants out. And they don't have enough money. The one that wants to keep doesn't have enough money to buy out the other member. But obviously the leaving member wants to try and get something. If this other person is going to keep going. So you get into this kind of endless cycle of going back and forth. Obviously, eventually, usually in those situations, the business ends up folding anyway, and now two best friends are usually fighting with each other. The last kind of thing, and I want to jump down to the next question and the back end of these slides, is a lot of times people don't realize they have done such a harm or injury in running their LLC and their business operations, and that there's some type of latent lawsuit. Maybe there's a harassment claim. Maybe there's a breach of contract claim that a creditor has not brought yet. Or, as I said, with taxes, maybe there's some taxes you failed to file and you need to clear that out. So going through some type of audit process, or looking through your books and records, or kind of self-assessing what have you done before closing, also tends to be a problem that can be easily overlooked. A lot of people said, yeah, I totally didn't do anything wrong, so there's no problems and I can proceed. Again, the problem being is that if you close and file your articles of termination too quickly, you could be exposing yourself to personal lawsuits. And that's usually what that fraudulent transfers gets at. As I said, some people make personal decisions to close down too quickly. And again, for creditors that are trying to get at that assets that have transferred from the LLC to the business owner, they would like to accuse them of, you had the intent of closing quickly, and you didn't address the disputes or problems with me. Jumping down to the second question. You know, you all intended to join this seminar and kind of learn a little bit of something. Who or what is what are you most concerned about when you're closing your business? If you guys have kind of muted me, because I realize attorneys, especially a corporate attorney, business attorney, can be monotonous. Please take the time to vote so I can kind of let everybody know. I know I might be ambient noise in the background. Okay. It seems to be slightly evenly split. I would just let you know is a couple of you are concerned about business partners, bank and financial institutions. I'm actually going to mention about the PPP loans for the bank situation. But several of you are concerned about the government and taxes and landlord. So I'm going to talk about something off slide based on that situation in terms of the poll. Leilani, if you could move to the next slide. You guys can take a look at the slide, but I want to address kind of why you guys came in terms of what your concerns are. Generally, when it comes to landlords and commercial leases, unfortunately, the reality is that the landlord has a lot of power. And so if you're closing down your business, they're going to want to extract as much from you as possible, including if they do have a personal guarantee, they're going to remind you of that. So in a landlord situation, usually, and this does tie back to the slide, is ideally if you're in a business type that somebody can be slotted into the lease, you may want to negotiate an assignment of lease or finding somebody else in it so that you can kind of get off the hook. Obviously, during an economic downturn, that is really hard to find somebody to kind of want to start a business, especially in a physical location. And also, not to mention, get the tail end of a term lease if that's what you have. But that is usually the best kind of solution is to get somebody else to slot into the space. Other options might be is to sublease or have somebody take over the business, and that's what this alternative options kind of addresses. That's kind of your commercial landlord situation. Again, going back to the disclaimer, a lot of times you have to really analyze the commercial lease and the commercial landlord you're dealing with, and what kind of business you have. Those tend to be the most problematic, but usually if you have a reasonable commercial landlord, even with a personal guarantee, it's like, look, what are you going to do? You can extract as much money, but at a certain point, even your personal assets are protected by certain exemptions if you have to declare bankruptcy. That is, if you go through the bankruptcy, the creditors can't get at those things because you need those to live. Like, they're not going to grind you down to the bone where you can't feed yourself. So that's kind of the bottom line. And for most landlords, they have an optimal amount of money they want to extract from their arrangement. It's just trying to navigate that. For government and taxes, yeah, the reality is I think a lot of people, when they're closing down, the sudden realization when they try and go for a tax clearance or square away their taxes, they haven't properly paid all their taxes. In that situation as well, usually the thing is that the owners of an LLC are still personally responsible for the taxes. Put it this way, Uncle Sam will always get paid. They just need to figure out how. And in that case, usually with taxes, if the tax bill is so high, usually the request is for some type of payment plan with the Department of Taxation or IRS. The starting point, though, is seeing a CPA or a tax attorney and making sure that you've paid all your taxes. And if not, what likely is the amount of interest, penalties, fines, and fees when you kind of go. And as I said, it's actually better if you keep the LLC going and trying to work out an arrangement rather than quickly closing the LLC and saying, I don't owe any taxes. That's not how that works. Moving down to the last slide, and then I will open it up to questions. I just want to touch on some of these questions that I recently got. So I frequently get this right now, and I get it. Everybody's in a pinch and pain. I get from the business owner, I'm not making money. Is an option of mine. Can I turn my business into a nonprofit? Usually what they're referring to is a 501c3 tax exemption status. That's like your Hawaiian Humane Society, the Blood Bank of America, the Kidney Association. And the key thing for those situations is those are charitable organizations. That is the money that they receive from people for existing and operating goes to some charitable purpose. There is a difference in you not making money or profit and the term nonprofit. So usually that is not the case from going something from a for-profit business that's no longer making money because of an economic downturn versus of starting up a nonprofit. That's usually not, that isn't going to work out that well. For a lot of retailers and stuff like that, they for small businesses, they have a lot of outstanding coupons is the way I put it, or things like that. And that's the next question. And they didn't put terms and conditions, especially for small business owners who obviously can't have a sweepstakes attorney or somebody write all that legalese in terms of the little ticket on the back of your thing. They don't realize that that's exactly what I'm talking about is contractual outstanding obligations is that you wrote on a piece of paper that, you know, for money exchange that you would do something for this coupon when presented. If you sit and think about it, that's much like a check is you write a check, it's for money. When you present it to the bank, you can cash it or deposit it. So a lot of times you got to take a look at your closing down process. And again, you sometimes have to address your customers and close out obligations that you owe to them, especially when it comes to retail situations because of consumer protection laws. I will save the employees to contractors because that's usually an alternative to restructure the business. But lately, what I've been getting is I took PPP money, that is a loan money, and a lot of people were like, am I going to be personally liable if I close my business, even though I took the money? Generally speaking, in that situation, is if you took the one that is 25,000 and less for the PP loans or the EIDL, the disaster loans, they generally have very favorable terms. And most times, even in bankruptcy, those can be discharged. That is, because they didn't require collateral or personal guarantees, defaulting on them is less bad than if you still owed or more traditional type of loan. I say less bad because just recognize if you are a serial entrepreneur type, if you default even in these times, it still goes on your credit history and with even if it's the PPP loan. And the thing is that if you want to finance or start a new business, you would now kind of have a default situation. Now, I don't know what that's going to look like 5 years from now when we've kind of got past this and the economy has kind of maybe restarted or jump started, but that is something to note. So that's why, going back to the bankruptcy situation is sometimes you want to consider it an option, but sometimes you want to take the harder road in negotiating down payment plans without having to go through bankruptcy or threatening it, because the default might impact your future plans or decisions in starting a new business or starting all over again when time allows. The bigger issue and usually the problematic issue with PPP money tends to be when you have one that is for the 25,000 or more, and usually that definitely requires working with an accountant, a financial advisor, an attorney to kind of extricate yourself that situation if you really can't get the business to keep going. And to be blunt, for this webinar, those actually tend to sometimes be the ones where you're still going to be personally liable for them. That is that there is nothing that can be done. So there is that risk of prematurely closing and rather than trying to weather the storm and wind down and pay back or deal with that loan. So just recognize is that's kind of the threshold is that 25,000 is less is generally easier and the 25,000 and more is going to be harder to close down your business. Okay, with that, I'm sorry I went over. I tend to do that, but I wanted to make sure you guys kind of got my crash course in closing down your business with particular emphasis on LLC. Do you have questions? If you do, go ahead and submit them and Leilani is going to help me moderate them. Any questions? If not, I realize we went over lots of meaty stuff and ideally we'll either follow up so you can get this recording and maybe a handout on some of the more meatier topics that I discussed today. Okay, it looks like we're good to go and nobody has any questions. Thank you everybody for attending and joining. Much appreciated for you spending your lunch break with us. I hope you were able to get some information. And like I said, we have your info for the sign up on the tickets from Zoom. And so we'll send out a follow-up blast. So if there are lingering questions or if you think of something, you can feel free to reach out to us. And maybe if you need an initial consultation or a referral, we can help you there. Other than that, thanks for attending and I hope you stay healthy and safe out there. Bye, and have a great Labor Day weekend. Oh, I'm so sorry. If anybody's still on the line, I missed, there was I didn't see it in my pop-up window. There was a question about typical time horizon for good wind down. For those of you still here, I'll answer that, but we'll send out the video and people can grab this in our link. In terms of, is there a typical time horizon for a good wind down? Usually it really depends on how many outstanding obligations and if you have more of a long-term operation, that is loans, commercial lease, term leases. But if you are some type of e-tailing or online retailers type of situation, or you don't have a lot of physicality, it really is just winding down those short term, and usually they're subscription based situations of just giving notice, canceling credit cards, canceling online subscription fees, or closing down your website domain and things like that. And that's going to be really as quickly as you kind of do it. Oftentimes when there's longer obligations, a lot of it is a negotiation process, and you need to give yourself a lot of breath and time. That's why when the decision to close down, it should be a real good commitment to closing down. Sometimes that's why some business owners choose to scale back rather than close down outright to see if they can weather the storm. Because even in itself, the winding up process, again, for those who typically have a more physical presence like a shop or a restaurant, the wind down process may be extremely lengthy because you have all these tangible assets that you have to get rid of, right? For a restaurant, you have kitchen equipment, tables, chairs, and then you got to clear out the lease space. And then you also have, while doing that, you have to deal with the landlord. As well as, if you have utilities, you have farmer and vendor suppliers, right? So there's more to deal with. So put it this way, is the more connections you have to your business, especially on the contract side, you have to unwind. I usually like to characterize it as a set of strings. The more strings you have to cut or untie is the amount of time you're going to have to spend getting rid of all those. Anyway, thanks for your question, Derek. Sorry I didn't see it, but that is a good question. And hopefully we can share this information with everybody else when we send out a follow-up email. Hope that answered. Other than that, again, thanks everybody for joining, and hopefully we'll get to see each other in person, or you get to join another webinar in the future. Thanks.